you've ordered books in advance, they're up the front here, so don't forget to come and see Janet afterwards and claim them. Otherwise they'll get sold to others later. Now what unfortunately I have to go backwards and forwards to here in order to press the button. So the starting point is of the need for a resource on customary law is basically a petition made by Kainuku Ariki, Tinamara Ariki and Pā Ariki on the 8th of August 1941 to the New Zealand House of Representatives. They basically said a number of land court judgments at Rarotonga have been questioned in regards to customary laws. And they basically said the land court was changing customary laws without first consulting the local population on their views on this important matter. So to put matters right, what they had asked for at the end of the day was an inquiry into customary law and that the land court stopped sitting until that inquiry had taken place. The final point there, which is also very important, there was a further meeting in 5 May 1942 at Taputapuatea Palace where Makia Nui Takao Ariki also supported that request. So it was all the Ariki in Rarotonga, as well as a lot of the Taiapoa and Rangatira, all agreed that the court decisions were wrong. The New Zealand Parliament did nothing. And there has never been an inquiry into customary law since that time, and the courts have continued making decisions basically with no knowledge of what customary law is because it has never been spelt out. Now, Ron Crocombe wrote his theses on land tenure in the Cook Islands in 1961, and what I've done in my book is incorporated his theses. He'd be chuckling, modified it where I thought he was wrong. Where I said he's wrong, I've made that clear. But his thesis was more detailed than his book, which was published in 1964. So without his pioneering research, this book wouldn't have been possible because he interviewed a lot of people who've, of course, since passed away. So many thanks to him. Now what I want to touch on briefly now is what he had to say, which was at the end of the day that again there had been no adequate determination of what customary law was, and in his opinion the land court had never initiated research to determine the nature of existing customs, and as a result, in his opinion, a large proportion of cases were not decided in accordance with custom. And again, if you don't know what it is, how can you make decisions as to what it is? Courts unfortunately have a horrible habit of finding a need to make a decision, even if they should really say, look, we can't because we don't have enough information to do so. Now, the conventional wisdom that I started off believing, which is what most people believe, was really as follows. That primogeniture was part of the Cook Islands customary law, i.e. the titles passed down from father to eldest son. That the Makia title in Rarotonga had passed down from father to son in accordance with primogeniture, from Puta ki Titahi, who was the son of Tangia Nui, and Mokaroa ki Aitu, who was Kirika Tawa Api's daughter, down to Te Pā Atua Kino. That Te Pā Atua Kino was the son, or perhaps an adopted son, of Rangi Makia Kia. Just to put him in the picture, he's about 1750, give or take a few years. That Te Pā Atua Kino became the Makia Ariki, not the Makia Nui Ariki, after Rangi Makia Kia. That he gave each of his 3 sons a title, the Makia Nui Ariki, the Makia Kirika Ariki, and the Kātini Ariki, titles being 3 new titles. So this is conventional wisdom, not what I believe now. The Te Pā Atua Kino had extensive landholdings in Rarotonga, inherited from his ancestors, which he divided between his 3 sons. And finally, that the three whaka of Rarotonga were formed many years before Christianity came to Rarotonga in 1823. And at that time, the Kia Nui Ariki was the supreme Ariki in Rarotonga. So that basically is the conventional wisdom that most people believed. Now, in the foreword to my book, which was written by Marjorie Crocombe, she made the point that since Ron Crocombe wrote his pioneering works in 1961, 1964, there has been no other detailed analysis published of the subject. But we're fortunately now in a better position to interpret customary law than we were back when Ron Crocombe wrote his book, as anthropology was just an infant type discipline at that time. And what's important to recognise, as Marjorie recorded, is there's now a lot more information and scholarship available on the subject than there was when Ron Crocombe wrote his book. For instance, we've all got access to the LDS church microfilms, which contain a lot of worthwhile material. And there's access to material in the Alexander Terminal Library, etc., which wasn't around before. So in terms of my book, I can blame one of my wife's aunties during Bowden for writing the book, because in 2006 I said yes when she asked me to help her in a complex land court case which she'd filed, and she didn't know what she was doing, and she asked me, who didn't know what I was doing, to help her. And when I undertook that case, I realised then, as a result of speaking with Ron Crocombe, that I was going to have to do a lot more research than I'd ever done in my life. And having started that research, I realised that the conventional wisdom which I had believed to start with had a whole lot of holes in it which just didn't add up, and the jigsaw puzzle pieces I couldn't put together. So I basically wiped the slate clean and started by saying, I don't believe anything. I'm going to rewrite things in a way that makes sense based on the material that's available. So when you're reading the book, what I ask you to do is basically do so with an open mind, as if you know nothing, and see whether what I have got in the book makes logical sense, regardless of what you've been told by your tupuna. Now, taking you briefly through the book, which you're welcome to have a look at, there's a copy at the back. Volume 1 deals with pre-European Southern customary law, history and society. So it deals with where you find the materials dealing with oral traditions, how oral traditions were passed on, the early discovery and settlement of the Cook Islands, what customary law is and its importance, how you acquire rights to land, conquest and warfare, and how land used to be utilised, and the role of land prior to Christianity. So that's volume 1. Volume 2, I'll just skip through a whole lot of pages here. These are just the index pages, which you're welcome to have a look at later. The person who designed the book was Trevor Newman, who designed Baka Moana, which won an award for the best book of the year. So I engaged his services, so what was my ugly book would start looking nice. So volume 2 deals with pre-European Southern Cook Islands Maori society. So it looks at the division of Rarotonga after Tangianui and Karikatala Api, succession to chiefly titles, the fearful season in Rarotonga, which was from about 1650 to 1823, where there was a lot of warfare and things changed dramatically. Social stratification, i.e. the chiefly titles and Taipo, Rangatira, etc. Religion and gods, social organisation, and the state of Rarotonga in 1823. There's also some information in there about the other southern Cook Islands, but my challenge to people from those other islands is that they start writing similar things. Just while I'm dealing with that, I'm off to early next year to Mitiaro and Manaia because they've banned the land court, which is maybe sensible. And in that case, customary laws apply and not court laws. So I'm going to do some research there in early next year on how their customary law systems work in those islands. So volume 3 deals with the mission period and its impact upon Cook Islanders. So it's from 1822 to 1888. Now this is not about missionaries. There are tons of books written about missionaries, mostly with rose-tinted glasses. This is about the impact of the mission period upon Cook Islanders. Just as an aside, does anyone know what holystone is? It's coral, and it was used to scrub tattoos off Cook Islanders. So there are a few nasty things that happened during the mission period which were not Christian at all. And my little point there is that the first missionaries to the Cook Islands may have been missionaries, but whether they were Christians is perhaps debatable. Enough said on that. Now, what I'm going to deal with now, and this is only a very small portion of the book, the most controversial portion of the book, so please don't be dissuaded from reading the rest of it by what I'm going to talk about tonight. So what I want to look at, first of all, is really how traditions are invented and the research you really need to undertake in order to establish whether the traditions are real or invented. So I'm looking at the holders of the Mukea Ariki title in Rarotonga. And these are all in my book. So according to Mukea Nui Tere Moana in 1952, there was a line of descent from Kurika Taraapi right down to her, an unbroken line of descent, i.e. it was all her family, not anyone else's family. And that's the evidence that the Mukea Nui family have basically given in every court case until the present Mukea Nui fight, which is ongoing. Mukea Tekau in 1890 gave a similar version of the title to the Reverend William White Gill. Again, much the same. The only difference here is that the names of the title holders were translated as to what they meant, rightly or wrongly, but it was the same version. Henry Nicholas, who's also from the Mukea Nui family, I understand, gave a similar version in 1892, and that's published in the Journal of the Polynesian Society. Then, so these are the genealogies which the Mukea Nui, sorry, they're not genealogies, I've got that wrong, they're lists of Ariki title holders, and that's what you need to understand. They're definitely not genealogies, only lists of Ariki. So the next one was the lists of the kings of Rarotonga as given by the wise men of Mukea and Tinamana in 1869. And again, that's much the same with a translation of who the people were. So let's look to the other Ariki lines in Rarotonga. Now, Kaukura was the common ancestor of Tangia Nui, Arera and Kainuku, who were the, Arera and Kainuku, of course, were some of the Ariki in Rarotonga before the arrival of Tangia Nui and Kurika Taraapi. And the reason they didn't fight was that Kaukura was the common ancestor. So they were all blood relationship. They all had a blood relationship apart from the odd one out to Kurika Taraapi. Now, Charlie Cowan was quite a good historian in Rarotonga. He collected lots of manuscripts which have been microfilmed by the LDS, which is why the only reason they're now survived. In his manuscript, which is film number, and this is all in my book, 1126511, so when you're actually quoting from these manuscripts, for those of you who've seen some of the debates on Facebook where I've asked people tell me where it's from, otherwise it's not worth the paper it's written on. Look, if you're doing research, make sure you write down where you've got it from, because otherwise you might as well not have done the research, as it's not worth the paper it's written on. And whatever you do, when you get printouts from things, don't write on them, because if you start writing on them and that goes into court, you're in strife. It's got to be a clean piece of paper with none of your editing on it at all. So this list of ariki, basically, which was from Charlie Cowan's collection, showed that all the Makia ariki were from the time of Te Ariki I Te Au down to the time of Rangi Makia Kia, were all descended from the first three children of Arera Ukara, i.e. they were of the Arera line. Now none of the Makia Nui listed ariki says who they're related to. This is one of the two lists of ariki that actually says which families they're from, and no one has changed this so far. And that was the rest of Charlie Cowan's list, going down to the time of Makia Kia. The next one who challenged conventional wisdom was Tuaiti Kakawa in an unpublished manuscript, and the significance of his manuscript was it details the Arera families who the ariki were from. And what's interesting with his analysis is that the title did not pass from father to son, i.e. Primogeniture was not part of Rarotongan custom. So and my question for people is, who on earth got the idea that primogeniture was? Where's the evidence for it? I haven't found any. And these lists of ariki clearly show that primogeniture did not apply. It was an exception to the rule. So that's not what I'm talking about tonight. It's part of the evidence that primogeniture was a European invented tradition. If you read Chief Judge Eison's judgment in the Makia Nui case, which was the start of it, there's nothing in that case which, no evidence that primogeniture was a custom. He read the Journal of the Polynesian Society and decided it based on readings of the journal, and every single judge after that has based their wisdom on a judgment which has nothing in it, i.e. Eison's judgment. So how that works, I don't know. Anyhow, that's to be decided by the Court of Appeal in June next year, where I'm the guinea pig. I'm telling the Court of Appeal that every single decision they've made in that area is wrong, so I'm not looking forward to that. So what I've done, and this is the first time it's been done, is put the lists of ariki, which I've just told you, in a chart format to compare them. And what I've done is I've numbered them. So I've taken Charlie Cowan's, and that's numbered 1 to 15, and the other ones I've put their numbers there. So the only major difference between those lists of ariki is, in some occasions, the order's slightly different. Some have more ariki than others, some have a few less than others, but they're all talking about the same people. So it's not different families. So basically either they're all from the Arera line, or they're not from the Arera line. It's